All right, it's 1 o'clock, and so I'm going to call to order public meeting number 97. It's hard to believe that we've gotten to that number, but it is. Public meeting number 97 of the Massachusetts Gaming Commission. The purpose of this public meeting is a limited one. It's set forth on the agenda. It's to explore the issues surrounding a land transaction between FBT LLC and Wynn Mass LLC, Wynn MA LLC, dealing with land in Everett on which Wynn, the applicant for a Class Category 1 gaming license, wishes to build its property. To set the stage a little bit, every applicant, including Wynn, undergoes a suitability investigation, and the hearing on Wynn's suitability investigation will take place on Monday. The investigation has been completed, and this is not part of the suitability hearing. But during the course of that suitability hearing, information came to the attention of the Commission's Investigation and Enforcement Bureau dealing with certain features of the transaction among the owners of the property in Everett that is the subject of today's hearing and meeting and inquiry. And the Investigation and Enforcement Bureau brought those issues to the attention of the Wynn principals. The Wynn principals took action that we'll hear about in response to that information and have filed with the Commission a petition and a request for a hearing to the effect of allowing the Commission to determine whether those steps were adequate to deal with the Investigation and Enforcement Bureau's issues. So today we're going to explore that topic. That's the agenda for today. That's the limited agenda for today. With me are Commissioners Stebbins, Zuniga, and Cameron. I'm Commissioner McHugh. Commissioner Crosby, the chairman, has recused himself from this particular hearing for reasons that he's stated publicly. So we'll proceed with the four of us. We will hear from the IEB to begin. Then we'll hear from the applicant's representatives. We'll have an opportunity for the commissioners to ask questions. And then at the end, we will have a discussion among the commissioners ourselves and announce the result of our conclusions based on the hearing. Because this is not a suitability hearing, we're not following the adjudicatory rules, we're not following the evidentiary examination and cross-examination that those hearings are typically accompanied by, but we'll proceed in the normal style that we have for public meetings with presentations by both sides. So I think we will begin with the IEB and with General Counsel Blue and Director Wells leading us off, and then we'll come to the Wynn side, which is represented by Governor William Weld, General Counsel Sinatra, and others who will be introduced to us as we proceed, I take it. Ms. Blue.
So thank you, Commissioners. We have before us today the petition dated December 5th of the applicant for your consideration. I would like to start by asking the applicant to introduce the folks that are here so that you can see who's here on their behalf.
If the members of the Commission please, my name is William Weld. I'm a member of the law firm Mintz Levin, and I represent the applicant Wynn Mass. With me is Kim Sinatra, who is the General Counsel of Wynn Resorts Limited, which is the parent of applicant Wynn Mass. Mr. Matt MADDOX, who's the President and Chief Financial Officer of Wynn Resorts Limited, which is the parent of applicant Wynn Mass, and Mr. Robert Laporte, who's a certified real estate appraiser and a managing director at Colliers International in Boston.
Thank you. And we'd like to proceed next by hearing from Director Wells with her report.
Good afternoon, members of the Commission. I'm here this afternoon to report on the findings of the IEB investigation into questions that arose regarding the ownership of the property in Everett that Wynn Mass LLC has an option to purchase should the applicant be successful in obtaining a license from the Commission. The Commission has been provided with the section of the Wynn suitability report that pertains to this issue. I will defer to the report for the details of the investigation and specific facts that were uncovered. I will highlight the significant areas that are relevant for the proposal before you here today. As a preliminary matter, as anyone with experience in law enforcement is aware, information sharing, particularly between different law enforcement agencies, is critical to ongoing success. It is no different with respect to the emerging gaming industry in Massachusetts. The commitment to working together and sharing relevant information was demonstrated by the FBI, who were extremely helpful to the Massachusetts State Police and the Investigations and Enforcement Bureau at the Gaming Commission. As is detailed in the report, as statutorily required, the land ownership of the property for the casino was examined for purposes of the suitability investigation, and due to the development of information shared by the FBI, the IEB conducted a more penetrating and broader inquiry into the ownership. What at first appeared to be a relatively direct transaction was revealed to be a complex web of questionable conduct by the sellers that required even deeper scrutiny as each layer of the transaction was penetrated. Ultimately, evidence was uncovered raising concerns about an intentional concealment of a hidden interest in the property for the casino. What is critically important to understand at this juncture is that it became readily apparent through the investigation that there may be additional information related to the parties at issue in this transaction that is beyond the scope of the IEB regulatory investigation. This was not a criminal investigation, but rather a suitability investigation, which is exclusively regulatory in nature. All information obtained during this investigation either has been or expect will be turned over to the appropriate law enforcement agencies for separate evaluation and investigation as needed. At this point, I would like to compliment and thank Lieutenant Kevin Condon and Detective Lieutenant Brian Connors from the Massachusetts State Police for all of their work on this investigation, along with Guy Michael and Robert Carroll from our consultant law firm. This investigation was conducted professionally and thoroughly and developed into one of the most complex and convoluted fact patterns to try to put down on paper. Thank you, Bob Carroll, for all of your work drafting that section of the report. To summarize the facts of this part of this investigation is extremely difficult, as the statements by the parties involved was at times conflicting, and based on the totality of the evidence, the veracity of those statements is at issue. Generally, the property at issue, which I will herein refer to as the Everett property, was purchased by the entity FBT Realty in 2009. Originally, the property was to be purchased in equal parts by Paul Lonas and Gary DiCicco. As is detailed in the report, that original plan changed, and Anthony Gattineri and then Charles Lightbody provided funding investing in the property. Dustin D'Annunzio retained an interest by way of his management role with FBT. I refer the Commission to Exhibits 8 and 9 for detailed background information on DiCicco and, most importantly, Lightbody, to evidence why the IEB had concerns about his involvement in the transaction. After Wynn executives visited the proposed site and met with the mayor and other city officials on November 27, 2012, a memorandum of agreement was executed between the applicant and FBT Realty. The general terms called for an option to purchase for $75 million with a $100,000 a month carrying cost. At the time, the owners of FBT Realty were specifically identified to the applicant as only Lonas, Gattineri, and D'Annunzio. On December 19, 2012, the MOA was followed up with a formal set of option agreements for the parcels of property in Everett and a smaller one in Boston. On January 14, 2013, the applicant, Wynn, filed its formal application for a Massachusetts gaming license. During July of 2013, information was developed which indicated the possibility that the property was being sold with a hidden or concealed ownership interest of one or more persons of concern to the IEB. The IEB subpoenaed certain recorded conversations between Charles Lightbody and an incarcerated Massachusetts state prisoner of significant concern to Massachusetts law enforcement. Please see Exhibit 10 for information pertaining to the inmate. Excerpts of those calls between July 2012 and July 2013 are detailed in the report, and I refer the Commission back to the report for transcribed portions of those calls. Although these conversations were conducted on telephone facilities where the parties are noticed of no expectation of privacy, they nonetheless brazenly spoke about the matters under investigation herein. While some of the conversations are overtly pertinent, some portions tend to be self-serving, guarded, and occasionally cryptic in content. Indeed, some content can vacillate between both involvement and withdrawal in the suspicious activities under investigation herein in the same conversation. However, the repetitive nature of the common theme of involvement when coupled with the conduct of the sellers during subsequent IEB sworn and documented interviews of the sellers and Lightbody himself, as well as their provision of various misleading and backdated documents, supports the proposition that an attempt to conceal the involvement of at least one convicted felon in this transaction was exposed by the investigation. The inquiry revealed a complex series of suspicious activities by the sellers which prevent the absolute final determination as to whether Charles Lightbody and perhaps Jerry DiCicco possessed an ownership interest in the project property at and/or after the time of the option agreement sale to the applicant. Further, the investigation also raised significant issues regarding the conduct of the remaining sellers, that is Paul Lonas, Dustin D'Annunzio, and Anthony Gattineri, during the period when the applicant became involved in the acquisition process, as well as during the course of the IEB investigation. The inquiry was also hampered by the refusal of Anthony Gattineri and Gary DiCicco to provide sworn testimony to the IEB via their assertions of their Fifth Amendment privilege against self-incrimination. Additionally, despite being subpoenaed to testify before the IEB, Charles Lightbody, too, refused to appear and provide testimony under oath to the IEB. Some of the specific concerns uncovered by the investigation are the following. As I indicated, evidence exists to suspect that Charles Lightbody, a convicted felon, may have retained an interest in the Everett property well after the applicant had been advised that he had been removed. Also, Charles Lightbody may have a legal reversionary interest in the event Anthony Gattineri does not repay his promissory note obligations. Also, documents were provided to IEB investigators that were said to evidence in written form the specified transactions, that is, promissory notes dated August 15th and December 14th of 2012, and memoranda of transfer dated August 15th and December 14th of 2012, and which to purport to have been executed on those dates, but in fact may very well have not been prepared or executed on the depicted dates. Also, sworn or recorded testimony of sellers provided directly conflicting information about when such documents were prepared or executed, including, for example, when certain promissory notes and memorandum of transfer for Charles Lightbody and Anthony Gattineri were executed. One document provided that a purported transfer of Gary DiCicco's alleged FBT Realty LLC ownership interest to Charles Lightbody occurred in April of 2012, despite no previous mention of DiCicco's ownership of such rights or interest just 4 months before in the entity's operating agreement. Dustin D'Annunzio provided sworn testimony that he personally altered the dates on the August 2012 promissory note and memorandum of transfer forms provided by his attorney to reflect the earlier date so as to provide documentary support after he and other sellers had been interviewed by the IEB investigators over 1 year later in July 2013. Also, Charles Lightbody, in graphic taped evidence, confirmed that he knew of the restrictions against felons' involvement in the gaming industry, and further that he and his partners were working to double or triple blind his interest in the deal. Also, Charles Lightbody filed for a 2013 mortgage and provided an application after the Wynn option agreement was executed, wherein he cited his interest in the FBT Realty LLC as a $10 million asset to support his collateral analysis for mortgage eligibility, despite he and other sellers asserting he was already out of the deal at least 4 months earlier in August 2012. On October 23, 2013, City of Everett Mayor Carlo DiMaria was interviewed by IEB investigators. Information developed by the IEB indicated that Mayor DiMaria had a long-term personal friendship with Charles Lightbody and was aware of his interest in the FBT property. DiMaria indicated in his interview that his only contact for FBT would have been Charlie, referring to Charlie Lightbody. More importantly, during the interview with the IEB, Mayor DiMaria indicated in response to IEB questions that Lightbody expressed that he was excited about the recent overwhelming approval of the Wynn Mass LLC public proposal by the Everett voters on June 22, 2013, and confirmed that in his, that's the DiMaria's opinion, it appeared that Lightbody was still involved and would financially benefit from the FBT transaction. This statement clearly contradicts the earlier representations that Lightbody had extinguished his beneficial ownership interest in the subject property before the applicant's option acquisition. Based upon the information developed in its lengthy investigation and summarized in the report, the IEB believes that a substantial basis exists to believe that material information was being withheld by the sellers from both the applicant and IEB investigators, false and deceptive information and documents were being provided, and evidence existed that at least one of the sellers, that is Charles Lightbody, possessed a significant criminal history and took affirmative steps to conceal his role and interest in the transaction so as to avoid jeopardizing the sale of the property to applicant Wynn MA LLC, and thus preserve the opportunity to share in the enhanced financial rewards due to the site's potential casino use. One important aspect of this investigation was to conclusively determine if the applicant had any complicity or knowledge of the misconduct and/or concerns outlined in the report by the sellers of the property. No evidence whatsoever was developed that suggested any involvement or knowledge of the applicant regarding the conduct at question in this part of the investigation. Once substantially completed, executives from Wynn were briefed on the facts of the investigation by the IEB. I informed them that I was deeply troubled by what was uncovered and I wanted to bring it to the applicant's attention. I did specifically inform the applicant that it was my opinion that these matters were of concern as director of the IEB and that the commission had not deliberated on the matter. Certainly, how the applicant proceeded at this point and their position regarding the sellers receiving a financial windfall as a result of a gaming facility was something the IEB would report on regarding the applicant's suitability. Also, the IEB and ultimately the commission must consider whether allowing the deal as it was structured to go through, a structure would rise to the level of being injurious to the interests of the Commonwealth under Massachusetts General Laws, Section Chapter 23K. Since notification of these issues, the applicant entered into intense negotiations with the sellers and have a proposal here for the commission's consideration, which is the subject of the hearing today. Thank you.
All right, Director Ells, thank you very much. Are there any questions before we turn to the Wynn side? Commissioners? No. All right. Mr. Will.
Thank you very much, Judge. Members of the Commission, as you have heard, the Investigation and Enforcement Bureau of the Commission has expressed to us, to Wynn MA, the applicant, concerns regarding the sellers of the land in Everett on which Wynn MA proposes to develop a casino, and in particular whether certain of the sellers were less than forthcoming or outright deceitful respecting with the Commission's investigative staff as well as with representatives of Wynn MA. Respecting the identity of holders of ownership interests in the land. The IEB, as Director Wells has indicated, did determine as a fact that applicant Wynn MA had no involvement in or knowledge at any time of the possible misrepresentations or misconduct on the part of any of the sellers. Members of the Commission, I personally have many years' experience in conducting criminal investigations, both as United States Attorney for Massachusetts and as Assistant U.S. Attorney General in Washington in charge of the Justice Department's Criminal Division. And I can say on behalf of the applicant that we have been much impressed with the thoroughness of the IEB's investigation and the professional manner in which they shared their concerns with us. We appreciate the Commission holding this hearing today so that you can decide whether the actions Wynn MA has taken to address the IEB's concerns deal with those concerns in an appropriate manner acceptable to the Commission. Applicant Wynn MA will present 3 witnesses today: Kim Sinatra, the General Counsel of Wynn Resorts Limited, the parent of Wynn MA; Matt Maddox, the President of Wynn Resorts Limited, President and Chief Financial Officer, which is the parent of Wynn MA; and Robert Laporte, a certified real estate appraiser and Managing Director at Colliers International, who conducted an appraisal of the current fair market value of the land in question based on its highest and best use under existing zoning, but excluding any possible use as a casino or any value attributable to the land's possible use for a casino. Our first witness will be Ms. Sinatra.
Thank you, Mr. Weld. Commissioners, thank you for having us here today. And I wanted to thank the IEB for, as Mr. Weld said, its thorough investigation and its collaboration with us in first advising us of the issues that arose as a result of their investigation, and secondly, helping us to craft a proposed curative action in the effort to continue to move our application forward. Director Wells, I will not repeat the information that Director Wells gave you. She did a pretty good summary of both the salient terms of the MOU and the binding option agreement. I would like to draw the Commission's attention to a few additional provisions that were included within the contract. First of all, and probably most importantly for the context in which we're talking today, is the provision that we refer to in our industry as the privileged license provision. It's one that everyone here will get very familiar with because we and our colleagues in the industry include as a matter of course in contracts this provision that has a couple of functions. Number one is it advises the contract counterparty that we are a regulated business and probity is important and at issue. It requires the contract party to cooperate both with our compliance infrastructure and with any applicable regulators. And lastly, it provides a remedy in the event that either the cooperation or the results of any investigation are unsatisfactory. In this case, as in many cases, the remedy is the ability to terminate without any adverse economic consequences to our company. For reasons that will be relatively obvious, we elected not to pursue termination, although because we would like to pursue our project in Everett, although we come forward with an amendment to the contract that we hope is sufficient to take away from the transaction the enhanced benefit, economic benefit, that casino usage would add to this valuation of this property. And so Mr. MADDOX will go through in a few moments the process we went through in identifying the piece of property in Everett that is at issue and his original calculation of the $75 million purchase price. I think that it would be helpful for you and for the record to fill in a little bit more about the process. As Director Wells mentioned, we put the land under option agreement at the end of 2012. We then, in early January of 2013, filed our application for probity with the Massachusetts Gaming Commission and continue all the way until Monday the investigation related to that probity finding. We moved along on many other parts of this project which were long and complicated and actually quite expensive, including the negotiation of our host community agreement, the first one in the Commonwealth, and our process to the first host community vote, which was held in June of 2013. We were incredibly gratified to have an 87% approval rate from the voters in Everett, convincing us that we had indeed chosen the right community to partner with for our project. In July of 2013, I received an email that was somewhat surprising to me from, I believe, Bob Carroll, indicating that he and some other members of the investigative staff needed to come to Las Vegas on an urgent basis to interview Mr. MADDOX, Mr. Aziz, who's the president of our Wynn Resorts Development Company, and myself regarding details related to our land transaction. While we had been interviewed on many counts and talked and provided documentation on a myriad of issues, the land issue seemed surprising to me that would require an urgent visit. But as we do, we cooperated fully, and within a matter of a few days, we sat for the sworn interviews. During the course of those interviews, it became apparent to us that the IEB, through its cooperation with law enforcement and access to resources that we don't have as a non-law enforcement agency, had developed information that cast some serious doubt upon the veracity of some of the information that we had received from the sellers of our land in Everett. Once they took the information that they had received from us and continued to work on the investigation, we continued to stay in touch on this issue because it was of some degree of importance to us, both regarding our internal compliance process and procedure and the viability of our project going forward. In The fall, the IEB, as Director Wells has mentioned, had developed the facts enough that they felt comfortable sharing with us the level of their concerns with respect to the sellers. Needless to say, we were quite surprised and significantly unhappy about the development. We had run our compliance process on the 3 designated principals from FBT, Mr. Lonis, Mr. D'Annunzio, and Mr. Gattineri, and they passed our background check without incident. That action was taken in December and January of 12 and 13, commensurate with the beginning of our relationship. And we frankly had heard nothing to the contrary as we proceeded through the 6 or 7 months that intervened. Once we had received the full set of facts from the IEB, we immediately sent a notice of default to the sellers under the privilege license provision of our contract, noting their failure to cooperate in good faith and give credible, believable evidence to the investigators. We immediately began a discussion internally as to whether or not there was a way to salvage this, our commitment to this site in light of the facts. And since the concern seemed to be additional value going to people of questionable character and, frankly, with criminal backgrounds, we decided that it would be worthwhile to undergo an investigation of the fair market value of the property without a casino use. Because assuming that these sellers would have the ability to sell to a retail user or other highest and best user in this redevelopment area, we thought that we would like to see the difference between the $75 million, which included, as Mr. MADDOX will outline, our specific casino use, what that lower value would be. So we engaged Mr. Laporte after reviewing his CV and the reputation of his firm. He did a full appraisal that he's prepared to discuss with you. His number ended up being $35 million as fair market value at highest and best use. So we began, as Director Wells has indicated, a period of intense negotiation with our sellers with the idea that the best we could do would be to be able to buy that property as a non-casino user. We were able on November 26th of 2013 enter into the 9th amendment to our option agreement. That sounds like a lot, but the original 8 amendments were extension of diligence periods. One of the complicating factors of this property is, as you know, its environmental condition. And so when we entered into the initial agreement, we had set a period of time to determine the allocation of liabilities for environmental cleanup. And it took our experts a long time to get the information necessary to enable us to allocate those liabilities. As part of the 9th Amendment, we were able to allocate those liabilities. So the $35 million fair market value is reduced by an additional $10 million, which will go into an escrow account necessary to achieve what's called a permanent solution under Massachusetts law. That will take care of the environmental cleanup necessary to get that property to a regular commercial use. We at Wynn will end up doing significant additional remediation of that site to accommodate a couple of things. Number one is we will address polluted sediment in the water in the Mystic River, because we will end up dredging the water that's in front of the property to accommodate both water transportation, which is an essential part of our plan, and a remediation and return of that riverfront to usable public enjoyment. Additionally, we will likely need to do underground parking to accommodate the parking requirements of our project. So that will be additional environmental remediation that will be required over and above what a strip shopping center, for example, would be required to do. So at the end of the day, we've gotten to a place with the sellers that the purchase price has been reduced to $25 million to them. Additionally, we tried to cover off this idea of who is actually the beneficial owners. I referenced to you that the original privilege license provision in the contract contained a warning and an obligation for them to cooperate. In addition, the language included the following note and representation to us by the sellers. To the best of seller's knowledge, neither seller nor any person associated with seller has ever engaged in any conduct or practice which any of the foregoing persons should reasonably believe would cause any such person to be denied any approval. Approval is a capital A, and that refers to gaining approval. When we got to the Ninth Amendment, and in light of the concerns both raised by our internal compliance rubric and the IEB, we included a representation in the Ninth Amendment as to the beneficial owners of the sellers, and that is attached to Schedule 3 to the Ninth Amendment. Reading from the Ninth Amendment, there is a representation from the seller that says Schedule 3, which we'll review in a moment, is a true and accurate list of each person with a legal or beneficial ownership interest, direct or indirect, in the seller, the percentage interest in seller of each such beneficiary, and the address of each beneficiary. It goes on to say, neither seller nor any beneficiary has made or has any agreement, whether oral or written, to make any payment to any other person or entity from the proceeds of the agreement, including without limitation any of the option payments made pursuant to Section 2.2 or any portion of the purchase price. Schedule 3 shows information consistent with that information was provided to us in November of 2012. The owners include Mr. Paul Lonis, Mr. Anthony Gantineri, and the D'Annunzio Group, LLC, wholly owned by Dustin D'Annunzio. So I think with that, I'll, if you have any questions for me, I'm happy to answer them. Otherwise, I'll pass the baton to Mr. MADDOX.
Questions, commissioners?
Is Mr. MADDOX going to address the form of calculation of the 10 million? How you came about to calculate the remediation cost?
He's not, but I can help you with that.
Okay, please.
So this site, of course, has been on the environmental radar for a long time. And so the sellers had done some preliminary work with respect to expected cost of remediation. And they had used a reputable consulting firm. We wanted to be sure that we believed and were in agreement with their conclusions with respect to that initial calculation of a permanent solution under Massachusetts law. So we hired a local consultant called GZA. GZA and GEI worked together over many months with respect to trying to establish both the initial environmental cleanup cost, which is this $10 million. They've come to agreement that $10 million gets us to that permanent solution. There was then a second bucket of environmental cost, which I outlined earlier as I call Wynn specific, relating to the sediment on the riverbed, as well as the potential underground parking.
What happens if even the initial remediation turns out to be more than 10 million? Because it's one thing to project the cost, but it's another to actually
Exactly,
do it.
and GZA better be very good because we've taken the risk that that $10 million gets us to the first permanent solution. We feel quite comfortable that that's an adequate number.
And let's just assume that the cost turns out to be more than 10 million. Is that a liability that Wynn has now acquired effectively?
Yes.
Okay.
Any more?
I'll hold until.
I've just a couple. As I understand it, the changes from the first agreement were, insofar as they're relevant here, were the change in the dollar amount, the allocation of cleanup responsibility money, and the listing of the 3 people who were to get money from the sale.
Yes, there were a few other cleanup changes around title survey and those sorts of issues.
Right, but those are let's say those are the 3 material changes that are pertinent here.
Yes, sir.
And who signed the schedule or the document or the appendix or whatever it is that listed the 3 people who were going to get the money?
Mr. D'Annunzio signed as the authorized signatory of FBT.
Did he sign under oath? Is his signature notarized? Is that representation notarized?
He did not sign under oath.
All right, and he's the only one who did sign.
Yes.
Okay, I may come back to that later, but I understand what you're saying. Okay,
Thank you.
Mr. Maddox.
Make sure this works. Good afternoon. What I'd like to spend a few minutes on is really the business opportunity. Why Everett? So if you look at Wynn Resorts, we have a division called Urban Wynn. Urban Wynn is about the Grand Hotel. It's reinventing the Grand Hotel. And in order to have a Grand Hotel, you need to be in the great cities of America, which Boston is. So when we looked at Urban Wynn, we decided that we would build a hotel first, with restaurants, with retail, with entertainment. That's the first thing you experience as a guest. And then you'll walk through into a casino. And the casino is really the engine that allows us to spend the money to revitalize and reinvent the Grand Hotel. So what do you need to build a Grand Hotel and restaurants and entertainment? For your business traveler, you need access, quick access, to the convention center. That's what they prefer. Everett is 10 minutes away from the convention center. For our international traveler, which we generate significant amounts of money from our international traveler, both on the non-gaming side and on the gaming side. In fact, in Las Vegas, 800 rooms a night out of our 4,700 rooms are dedicated to our international customer. And over half of our table games business comes from Asia and 25% from Latin America in the United States. So our international business is very important. Now, what do they need? They need the Grand Hotel, the great experience, and easy access from the airport. Everett is 10 minutes away from Logan. For our local patrons, the local patrons need access off highways and the ability to move in and out quickly. This site is right off the 93, which has an average of 120,000 cars passing by a day. So when you take a look at Everett, it really fits the model for the Wynn Grand Hotel. We were looking, after our experience in Foxborough, for an Everett model, looking at various communities. And I actually saw an article that Mayor DeMaria had said he would be supportive of an integrated resort development in Everett. So I began investigating Everett and noticed that it actually met a number of the criterias that could support Urban Wynn. I immediately talked to Kim Sinatra, and we placed a call into Mintz Levin to ask if they could arrange a meeting for us with the mayor to talk about potential opportunities in Everett. That was in November of 2012. Within a couple of weeks, we had arranged that meeting. We also were contacted by the owners of the site. A gentleman named Trip McCoy reached out to me. He had been, I believe, retained by the sellers to reach out to various casino companies to gauge their interest in the site. So on the same first meeting to Everett, we set up a meeting with the mayor and the people in City Hall, and we also set up a meeting with Dustin D'Annunzio. That was the manager, the property manager for FBT Realty, to walk the site and to understand it. When we met with the mayor and his team inside City Hall, they had a large chalkboard, and on that chalkboard was a map of Everett. And this site was in orange as the redevelopment site for the city of Everett. Over a number of years, they had hired Sasaki, the firm, the local firm here, to think about ways to reinvent the Mystic River, urban renewal, mixed use. They'd had multiple public meetings about what can you do with a 30-acre site 10 minutes from downtown Boston on the Mystic River. There has to be some way to energize this area. And so when they were showing us this site, and we indicated that we were going to look at it later in the day, I proceeded to tell them about what Mr. Wynn does and what Wynn Resorts does, and how the best way to revitalize an area that needs an economic boost is a grand hotel, $1 billion property, 5,000 jobs, and the ability to generate hundreds of millions of dollars of revenue for the state and for the city. That will create true economic redevelopment. At the end of the hour with the mayor, I believe he was quite excited about the idea, much more so than the mixed-use retail apartment ideas that they had been pursuing. I then contacted Mr. Wynn and told Mr. Wynn that we had what appeared to be a city, and that was the most important thing for us, a city that seemed to be behind the idea of revitalization of casino resorts. We decided to engage in the process. Later in the afternoon, Ms. Sinatra and I went and walked the site with Dustin D'Annunzio. We looked at various floodplains, Google Earth maps, tried to understand what was submerged, what was above ground, how can we build on this site, just to make sure that we could at least take a hard look at it, that there weren't any showstoppers. And we decided at the end of that meeting that we should pursue this. We did not discuss price at that meeting. We then left Everett, flew back to Las Vegas, and I began working on modeling to see what is it that we could pay for a site like this. I employed the capital asset pricing model and also an income-based approach, which basically says how much can you pay for the real estate before you build the building in order to justify your returns. As you'll find around the country, integrated resorts and casinos will typically pay somewhere between 8 to 10% of their project costs will be dedicated to land. Sometimes they're quite a bit higher than that, and those projects oftentimes will struggle. But if you look at our project and our thinking of $1.3 billion, and if 8 to 10% of it was allocated to land, then the price could be justified. We could, we could begin the negotiations. We had some room. So, of course, I started the negotiation at $25 million, and they countered at $150 million, and actually walked through the exact math that I had performed, the capital asset pricing model, the income approach model. Here's what you could make with a casino. Here's what typical land allocations are. We negotiated for quite extensively over a short period of time, many emails, many phone calls, and ended up settling on $75 million, but with the obligation of the environmental cleanup to get to a permanent solution should be on the sellers, and then there would be a small sharing of incremental environmental cleanup. At that point, we executed a memorandum of understanding, and we then, our lawyers and myself, we moved to the formal documentation and executed the option agreements before the end of the year in advance of our filing of our application. So that's the history of why Everett and why $75 million.
Good, thank you, Mr. Maddox. Questions?
Yeah, so when you arrived to 75 million, the obligation was on the sellers to come to a permanent solution for the remediation, is that correct?
The permanent solution per the Massachusetts state law. So not if there's incremental remediation required due to some of the issues that Ms. Sinatra talked about, that was still a negotiation.
Is this the difference between what was the land remediation versus the dredging that might occur as part of the casino use?
Yes.
Was there a quantification of what that may be at that time? How much remediation it would take?
Of course, they had a quantification of $7 or $8 million provided by their consultant with lots of reports. But we didn't take that at face value. We hired GZA, one of the top environmental consultants in Massachusetts, and they embarked on a 6-month project studying the land, testing it, and came back to us with what they thought a permanent solution would be, and then what they thought could be required as incremental cost if we pursue certain things in the project. So the permanent solution was, in fact, fairly close to the number that the initial sellers had given us.
Or in other words, 10 million.
Yes.
What is the incremental cost that GCA has now come up with for the remediation?
The incremental costs are still being reviewed because it depends on a number of things in terms of the underground parking, and if we go down 3 levels or 5 levels, if we have to build a slurry wall, the amount of dredging we will do, all that will come through in our MEPA filings with our environmental piece. But it could be an extra, I would say it could be an extra $10 to $15 million. But it's too early to say right now.
Fair enough. But you assume that liability so you can figure that out when you get there. Is that a fair statement?
That's a part of our project budget as a contingency in the project.
Okay.
Good afternoon.
Hi.
I was interested in your statement that you saw or you heard that the mayor was interested in talking to someone about a potential casino. Is that correct?
Yes.
And when you met with the mayor, were there other parcels of land, or was this the only parcel of land that would accommodate such a project?
So if the maps are still up in City Hall in Everett, I'm not sure if they are, but when we walked in, they opened a very large map, 3 feet by 4 feet. And there were actually 2 large parcels of land, both in orange. However, one was further inside of Everett and surrounded by residential community. So the mayor had said that they're really focused on that being more parks, fields, low traffic zone in their urban renewal, and that this was the only parcel that they were looking at for large mixed-use development.
I see. And you also mentioned, Mr. Maddox, that you met with an individual who was representing the sellers. Is that correct? I didn't take his name.
Yes, a gentleman, I didn't meet with him. Trip McCoy,
Yes.
I believe, had been engaged by the sellers because he was a former investment banker at Bear Stearns that covered the gaming industry,
I see.
to go to the various companies to see if there were interest. Trip McCoy sent me an email, and I talked to him by phone. I never met him.
Okay.
He just arranged the meeting with Dustin D'Annunzio.
So the sellers were only interested in dealing with a casino company? Was that your understanding of his conversation with you?
His conversation with me was they have multiple people interested in this parcel, as you can imagine.
People
someone trying to
meaning
sell something.
casino companies?
Absolutely.
Okay.
Are
Thank you. And last question. You gave us a synopsis of the negotiation, the 25, the 150, and several emails. Who were you negotiating? Who was the person?
Dustin D'Annunzio.
Okay. Thank you.
As I understand what you said, Mr. Maddox, the responsibility for the site cleanup as part of the deal you signed with the sellers was to be for the sellers, but the amount was to be determined at some point down the road. Is that right?
That's correct.
And that's what led to those 9 extensions that Ms. Sinatra referred to a minute ago, because GZA was preparing its analysis. Is that right? When, in relation to the time you read the article speaking about Mayor DeMaria's interest, did you hear from Trip McCoy?
It was all within a week or so time period.
Had you made contact with Mayor DeMaria before you heard from Mr. McCoy?
No, I had not. Again, my first meeting with the mayor was actually in City Hall.
But you arranged it somehow. How did you arrange that meeting?
Ms. Sinatra contacted Mintz Levin and ML Strategies.
That's right. You said
and they set up the meeting.
That's right. And you never met with Mr. McCoy? You never met with Mr. McCoy?
No.
Okay. All right. Thank you. Other questions?
A couple of quick questions. Again, getting back to the the offer price, were you aware of the purchase price of the property by FBT before you had offered, I think it was $25 million was your starting offer?
I had been told by a local developer here that he thought they had paid somewhere between $7 and $8 million in 2009 for the property.
Okay. And can I ask you what your initial reaction was to the counter of $150 million?
I said, that's ridiculous. Of course, we're not going to pay $150 million because who's going to spend $2 billion on this site? Now, they thought that we could be because we do spend more money than anybody else on our resorts. Right. And they had just employed the investment banking model of 10% of project cost. So they had a reason for the number, and the negotiation began. Of course, when, they paid $8 million for it in 2009. That was a very depressed time. As an example, Wynn Resort stock was $15 in 2009. Today it's $180. So prices have moved up since 2009. That's a fact. Across the board, in real estate, everywhere. So I didn't start with $8 million. I knew that it was worth more than $8 million. And with Assembly Square going up right across the river and the values that have been paid over there, I started at that range and determined that that's the right place to start.
Okay. Did at any point as you were seeking out the mayor, pressed or following up on the mayor's interest, did you contemplate with them the whole notion of the Urban Wynn initiative, the strategy, the design, the development, the uniqueness, because I don't think you've done this anywhere else in the world, if I'm not mistaken. At what point did that enter into the conversation, either with the sellers or with the local officials? This kind of unique concept that you were putting out there.
So within Wynn, we had developed the concept clearly before.
Right.
And in the first meeting with the mayor, we spent an hour on that concept, that we're going to take everything we've learned and we're going to develop it into an urban model, because we believe that the Grand Hotel, his days have been long gone. People just don't build great hotels, grand hotels anymore, because it's hard to get the room rate to justify. So Mr. Wynn came up with the idea that if we have a casino to power this and we do them really well, other cities around the country are going to like it, and they're going to notice it, and they're going to want one. And Boston was clearly one of our first choices because it already had the legal framework in place for gaming that would allow us to develop this project.
Thank you.
Further questions? All right, thank you very much, Mr. Maddox. Mr. Laporte.
My name is Bob Laporte, and I am a managing director of the valuation group at Colliers International, their Boston office. Just so you know, Colliers International was formerly Meredith and Grew, and in 2007 we sold our 80% interest in our company to First Service that owned Colliers. Part of that, I had been with the company since 1982, and I transferred my position to the Valuation Advisory Services Group, and I am now managing director of the Boston office. Professionally, I am a member of the Appraisal Institute, have an MAI designation. In addition, I've been past president of the New England chapter of the Appraisal Institute, and nationally have been vice chairman of the Ethics Administration for the Appraisal Institute. I'm also a counselor of real estate and have a CRE designation. My education includes a degree from St. Anselm's College in Urban Studies, and my formal appraisal education has been principally through the Appraisal Institute and their courses. I hold licenses in Massachusetts as a real estate broker and as a general certified appraiser. I'm also licensed in the states of New Hampshire and Maine. I've appeared as an expert witness in valuation matters, in the Superior Courts of Massachusetts, including Suffolk County, Middlesex County, Dukes, and Worcester County, and Norfolk County. I've appeared as an expert witness in the Federal Tax Court and the Federal Bankruptcy Court here in Boston, Worcester, and Milwaukee. Some of the clients that I've worked for include, in the Commonwealth of Massachusetts, the Department of Transportation, the Division of Capital Asset Management and Maintenance, DCR, and the Attorney General's Office, where I've been retained by them as an expert witness in valuation matters. I've also completed valuation work for the Justice Department regarding contamination issues at the old Naval Air Station in Quincy and one on the South Shore. The type of work that I principally do is commercial real estate. Being part of a full-service commercial real estate company, we have a lot of appraisal experience in everything from office buildings to shopping centers to industrial properties. And I have been associated with Meredith and Group Colliers for 32 years and really had an opportunity to work on some pretty interesting assignments during that period of time. What else? I can go through the appraisal process that I undertook in this appraisal and talk about some of the assumptions that I made at the beginning of the assignment in order to complete my evaluation.
I think that'd be helpful, Mr. Laporte. This is not an ordinary appraisal for reasons that we've already heard about. And so I think it'd be helpful for us and for others who may be watching to understand how you went about establishing this value.
Well, we follow, as a real estate appraisers, what's called the appraisal process. And that includes everything from defining property rights that are being appraised to identifying extraordinary assumptions and hypothetical conditions. And I think in this regard, I think there are a couple of, there's one hypothetical condition and some extraordinary assumptions that I've used. With regards to the hypothetical condition, my valuation instruction was to assume that the site was environmentally clean, with knowledge that the site has had a history of known environmental conditions, but I was to assume that the site were available for development to its highest and best use, and that any stigma or any conditions involving environmental cleanup had been resolved. The second salient assumption that I've used is that I was specifically asked to preclude a land valuation that would take or account for a casino use of the property. So that particular use was totally disregarded in my analysis. And then I've made some other assumptions as to land area, how much of the site is usable. But in the course of what I'm doing, I'm looking at a lot of the relevant property characteristics that this 35 acres had, its location, and its proximity to population and zoning. Zoning in this regard, zoning had historically been industrial on this property. When the property was acquired in 2009, it was industrially zoned. And as of the date of my evaluation, there were zoning changes in place that would allow for a commercial retail development on the property. And I thought that was a significant change and noted that the city of Everett had, through Sasaki, had really identified this whole neighborhood as being more appropriate for commercial development than what the industrial zoning allowed. With that, I then took a look at some of the demographic characteristics of this property. And interestingly enough, they're pretty significant. Within a 15-minute drive of this property, there are 500,000 residents, and that represents about 7.5% of the state's population. So in terms of a commercial retail use, there's a significant population, number of households available in this area. I then looked at some of the data services that we have, such as CoStar, and I did a vacancy report of commercial space within a 3-mile radius of this property, and the commercial vacancy rate is currently 2.5%. Then I looked at some of the other developments, such as Assembly Row. Company is representing the developers of Assembly Row in the office component of that. And as you've recently heard, there's a 700,000 square foot lease on a office building that will be constructed on Assembly Row for Partners Healthcare. All of these things pointed to me that this area is really in the development phase of its life, real estate life. And given the population and density, I use that as part of my highest and best use analysis. Highest and best use is really what is the optimum use of that land, what's legally permitted, what's physically possible, and what is financially feasible. So in looking at this site, there's approximately 22 usable acres. And it is in terms of urban Boston in the inner suburbs, a 22-acre assembled site that's zoned commercially with the demographics and access that this property has is a rare commodity. Usually when you look at development land, it requires, where you need to acquire 20 acres, you have to go out and assemble many sites to get a development site of 22 acres. So in looking at this, I'm looking at zoning, I'm looking at the location of the property, what's physically possible on the site. I'm precluding any contamination or environmental issues that would interrupt the development of the site. And I came up with the highest and best use that this is a retail development site. So with that conclusion, I then looked at, we have 6 valuation techniques when we value land. And I looked at comparable land sales and analyzed those land sales. And then I looked at one time, shortly after the property was acquired, they had entertained 2 tenants to do ground leases on the property, Walmart and Lowe's. And they had proposed in a letter of intent some ground rent payments for those, to develop the land for those 2 uses. So I analyzed both comparable land sales and I looked at what the potential ground rent payment would be for this site and capitalized that into a value indication. At the end of the day, I reconciled those 2 approaches, and in my opinion, the market value of the property, again, subject without any contamination issues, and for a retail commercial development disregarding a casino, that the site had a market value of $35 million.
All right, sir, thank you. Questions?
Yes, I'm just following your income approach calculation. You used 6.5 or something like that cap rate.
6.75.
6.75, and you also had I don't have it right in front of me, but you had some comparative cap rates a little higher.
I had one higher and one lower.
One higher and one lower.
Yes.
Where are those from?
One site was the land lease sale in the town of Waltham on Sayon Street, and the other one was in Revere.
And what were those amounts?
Those
cap rates.
Yeah.
No, the cap rates in each of those places.
7.25% in Waltham and 6.25%, I believe, in Revere.
Would it be fair to say that, you mentioned that there was a commercial zoning change
Yes.
since 2009? Do you
Yeah.
know when was that precisely?
In the fall of 2013.
So it might be fair to say that just by that change itself, there has been some appreciation to the land?
I think the change is the highest and best use of the land. So I think a lot of value has to be ascribed from taking it from an industrial zoning district to a
Commercial use.
commercial.
Further?
I actually had a question for Mr. Maddox.
Could we finish? Could we finish with Mr. Report, if that's all right?
That's fine.
I want to just step back a little bit. But first of all, when your assumption is that the site is clean, that means that you take into account, in determining the highest and best use, the site that's already been decontaminated. Whoever pays for the decontamination is irrelevant to getting there from a pure valuation point. Isn't that right?
That's true, Your Honor.
Okay. So so let me back up and just see if I understand this in a little bit bigger picture sense. What you're trying to do here when you're making a valuation is figure out the market price with the assumptions that you've made that the owners can get for the land. Isn't that ultimately what you're trying to do?
Yes.
And the value you're trying to establish is the value that any owner of that property could get. It's not owner-specific. Isn't that right?
What any buyer,
What any seller could realize from the sale of that land.
correct.
So it doesn't have anything to do with the identity of the seller, these valuations.
No, I don't look at any ownership
Right.
issues. I go out,
Right.
could be
And,
John Q.
and,
Public.
and it's fair to say that the market price is the price that a willing buyer, somebody who wants to sell, would receive from a willing seller in a free and open market when neither was under a compulsion, i.e. the seller had no compulsion to sell and the buyer had no compulsion to buy. That's basically what
Yeah,
a market
that's a
price is.
good point, Your Honor. I look at,
Well, I'm just the commissioner today.
yeah, well, okay. Commissioner, sorry.
That's all right.
It's, when we do these appraisals, we don't specifically say there's a specific buyer and he might pay a specific price. We look at open market, irregardless of who owns it and who might be interested in buying it, just.
And the one departure from that general approach to this process that you made in this case was that you discounted use for a casino.
That is correct, Commissioner.
Now, in making the computations that you've described and that you discussed a little bit with Commissioner Zuniga, you used two different approaches, did you not?
Yes,
One is called the comparable sales approach.
yes.
And could you just describe in general terms what the comparable sale approach is? I don't want you to go into detail, but just in a general sense, what are you doing when you use the comparable sales approach?
What we do is go out into the market, look at market participants as to, again, keeping in mind that there is no piece of real estate that's identical to another piece of real estate. But we go out and look at what market participants have been paying for commercial land. And keeping in mind that no two sites are identical to one another, we go through an analysis of those sales, looking at location, physical characteristics, and make adjustments to those prices that reflect the subject's quality.
And you take a look at actual sales data, and then you use your experience and judgment to make adjustments to relate that sales data to this site. Is that fair to say?
Yes, it is.
And the second method you used in this case was the income approach. Is that right?
It's called ground rent capitalization.
Okay. Could you explain again at a layperson's level of detail what that is?
Well, what happens in this approach, we look at what market participants are leasing ground for development of commercial activity. And so we establish what the ground rent would be under those conditions. And we then make a deduction for any expenses that are appropriate and convert that ground rent into a value through a capitalization process. And that's what basically is a premise here.
And with similar, at a similar level of generality, how do you convert how do you do that conversion you talked about at the end?
The reconciliation of the two approaches?
No, the
To
conversion.
the ground rent?
Yeah. Into a value.
Yeah, what we do in terms of capitalization, we look at actual market transactions as to what investors are paying for leased land. And secondly, we have national publications. Pricewaterhouse publishes capitalization rates as to what different types of investors are looking for on net leased properties. So through those two sources, you arrive at what's a market capitalization rate.
And the capitalization rate is really what an investor would expect to get as a return on an investment. Isn't that right?
Yes, it is,
And
Commissioner.
so if, say, the investor was looking for a return of 10% and had $100,000 to spend, that would yield that amount.
It would equal a value of $1 million.
Right. This is not the first time you've done this.
No.
Could you tell us approximately how many times you've performed a similar analysis through the course of your long career?
Well, I've been in this business for about 45 years, and 95% of my time is in market value appraisals. And they're in the thousands in terms of how many appraisals I've done.
Using essentially the same tools, different properties, but essentially the same tools.
Same tools, same process.
And these are tools that are not unique to you. They're standard tools in the appraisal industry, are they not?
The work I did conformed to the uniform standards of professional appraisal practice.
And you've appeared in Superior Court, you said, on a number of occasions.
I have.
And can you estimate, and you've basically described for juries or judges the kinds of analysis, approach, and results that you've described to us today. Is that right?
I have on many occasions.
And can you estimate for us the number of occasions you've done that?
Probably about 100 at this point.
Okay. I have no further questions. Any questions?
I think our general counsel has a couple
Oh,
questions.
no, I mean just
Oh,
for Mr. Lepore.
Yeah, no.
Okay. Now, you had thank you very much, Mr. Lepore. Commissioner, you had
Yeah, I
another
was just
question.
curious, what, Mr. Maddox, you mentioned the capital asset pricing model. What discount rate do you normally use these days? Or did you use for this to come up with?
I would have to go back and look at my files. Our weighted average cost of capital varies depending on our cost of equity and the volatility in the equity between 7 to 9%. And the cost of debt, if we're just looking at it on the debt side, is between 5 to 6%.
Okay, so it's essentially your cost of capital that
Yes,
you take into account.
yes,
Okay.
that's how I look at it.
Thank you.
Mr. Weld, anything further from your side before we come back to the IEB side?
No question.
Okay. Thank you.
I have just a couple of questions for Ms. Sinatra. You mentioned the privileged license provision. Is it a provision you commonly include in your contracts, and if so, can you explain why?
Yes, is the answer to, is it commonly included in our contracts? And the reason is that we are subject to licensure in more than one jurisdiction. And as you'll hear about on Monday, we have a relatively complex and robust compliance infrastructure. And in a transaction like this, we would where we had a big diligence period of time, we would continue to monitor any developments. And so we need to have contract counterparties who are contractually obligated to cooperate with us and with our regulators, because it happens on a regular basis.
And you mentioned in your testimony that when Michael and Carol came out to Las Vegas, you were surprised at the information that you heard. Is it common to get information like this? I mean, can you kind of describe your reaction in a little more detail?
No, it's not very common. I've actually been doing this for a long time. I've been with Wynn for about 10 years, and before that, I worked, and I was the general counsel at Park Place, which was, at that point, the largest casino company in the world. And prior to that, I worked for Merv Griffin when he owned Resorts International in Atlantic City. So I've been doing this a long time. I frankly have not, in my career, seen a fact pattern like this. Clearly not under my watch or a company with whom I have been affiliated. I was shocked, and the sellers were made immediately aware of the degree of our intolerance for such behavior. And as I say, you will have the opportunity to discuss with us and with our compliance and security people on Monday some of the actions we took in connection with this case and in the connection with the ordinary conduct of our business. But no, this is not a regular occurrence for us.
And how quickly after you got this information, did you start to put a plan in place or decide to take action on it?
Well, it was immediate, because Jim Stern, who again you'll have the opportunity and the pleasure actually to meet on Monday, is our global chief of security. Mr. Stern happened to be in the building, and so when Mr. Carroll and the FBI agents and state police were in our conference room conducting our sworn interviews, we invited Mr. Stern down, talked to him about the names that were surfaced with us. And he immediately began some additional diligence. So this is not something that goes through a big bureaucratic process. But one of the things that I think we pride ourselves on is, from Mr. Wynn on down, compliance and regulatory adherence is something that is core to what we do. It's the reason that we can be as successful as we are. And the only thing that took us so long to get to final resolution on November 26th was that there was a continuing investigation. And so we continue to collaborate with the IEB in the finalization of our overall report and in the resolution of these issues. The first time that we saw, actually some of the facts that I saw in the report, the first time I saw them was in the report, but the first time we were made aware of the tapes and other pretty salacious information was within the past month.
December 3rd.
Thank you, Mr. Wood.
And then finally, I believe Commissioner McHugh asked you if the document was signed or notarized. Do you recall if you received any supporting documentation for Mr. D'Annunzio's authority to sign that document?
We did not. What we relied upon starting back in November of 2012 were the Secretary of State records from the Commonwealth of Massachusetts. As everybody knows by now, this property is held in an LLC, which is quite common in the real estate business. But public records available with respect to LLCs are somewhat limited. We were gratified to know, frankly, in the end of 2012, that the 3 people who had been disclosed to us were the 3 people who appeared on the official records of FBT as Mr. Gaquin from Mintz Levin pulled off the Secretary of State's website. And so we corroborated it with a public records check, and so that's what we corroborated it.
I have no further questions.
I have a couple of questions. Ms. Sinatra, did you personally negotiate with the sellers after you were made aware of certain of the information that came from the IEB investigation?
So the negotiations were generally took place with our outside lawyer, who was Dan Gaquin, a partner at Mintz Levin, and Paul Feldman, who is the outside attorney for Mr. D'Annunzio.
You mentioned that you were surprised and unhappy earlier to hear some of this information and that you immediately advised the sellers. Is that through the attorneys, or did you have an opportunity to let them know that you were unhappy?
Oh, no, that time I picked up the phone.
You did?
Mm-hmm.
And did they react in any way to your surprise and the fact that you were unhappy about this?
Well, I was actually surprised that all of this investigation and interviewing had occurred for a period of months, and we were unaware of it. I'm sure from the IEB's perspective, we were unaware of it because it was a developing investigation. I was surprised that the sellers hadn't called us to indicate that they were having any issues with the IEB investigation.
Did they react when you brought these issues?
They have continued to maintain that there are 3 equity owners, and they have continued to be willing to submit to us in writing and confirm that those are the beneficiaries of our payments, both on the option side and on the full settlement of the contract.
Did you or the individuals negotiating have an opportunity to discuss the details of this investigation? Some of the information that was developed that may lend itself to question their assertions to you that they are the only 3 owners?
We actually weren't aware of it until very recently,
right.
and so we didn't get into, frankly, who shot John, because once the regulators told us this is a problem, we go into the mode of saying, okay, we're not going to relitigate this, and I think that the IB would probably admit they haven't come to a conclusion or a criminal investigation.
Correct.
So we took the facts as presented to us by the IEB, the seriousness of the concerns expressed by them, and immediately tried to fashion a response. It's not generally our nature to be overwhelmingly argumentative with regulators. They came to us, we believed them, and we pursued a path of cure as opposed to arguing.
The negotiations with the sellers, I mean, obviously you were able to get to a place where you're comfortable and your appraiser tells you that that's an appropriate price based on the methods. Was that a difficult negotiation because the sellers were not admitting to any wrongdoing?
Sure it was. And they suffered a severe diminution in the value that they thought they had on this piece of property. But I suppose they could have looked at it that if we terminated this agreement and went away, the best they could do would be a fair market value for another use. And so it seemed that once you get beyond the emotion, that rational business people may come to a place that they were willing to accept that as the conclusion.
Okay, thank you.
Anything further?
Just to follow up on that, you get the market value appraisal back. Was there any? I mean, you know, essentially for the sellers, they got somebody on the hook, but certainly the next potential buyer is unforeseen or is maybe not even on the horizon. Would you even try? Was there any thought about trying to negotiate a lower purchase price than what the market value came out as?
Now, Mr. MADDOX always wants to negotiate a lower price.
I assume you would, but I'm asking you that question. I know what answer he'd give me.
We actually, Mr. MADDOX had a pretty good view on what the comps were. So intuitively, he sort of had an idea of where Mr. Laporte may come back. And so we had an indication of value. We, frankly, did not want to mess around. We're incredibly serious about our intentions here in the Commonwealth, and we knew what we had to do. And so we basically sat them down and said, this is the best that can happen for you. It enabled us to close up the environmental discussion, which had been ongoing for a long time, and resolve a lot of other issues. And so for us, it was a relatively straightforward negotiation.
So that amendment has been executed.
Yes, sir.
That's what's before us, but it's not contingent on anything necessarily.
It's not contingent, although it does provide and reference that the commission needs to be accepting of this resolution.
Fair enough.
Commissioner Stebbins, were you finished?
Yes.
Yeah. Anything further? All right, anything further from the IEB? Does the IEB have anything
No
it
further
wishes to add at this point?
No.
All right, I think our input is completed. And now for some output. Discussion.
Maybe somebody can confirm that this beneficial ownership clause, can we be comforted that that's the most that these sellers are going to get? What's before us with this amendment?
Well, I think we've certainly heard that that is the agreement. That's the agreement that's before us for the $35 million gross, less up to $10 million in decontamination fees. One thing we could think about is whether we would insist on all three of the principals signing the nobody else is getting a share of the proceeds exhibit. But it seems to me that the deal that we're approving is the $35 million gross deal and nothing else. And I think we have to make that clear in whatever we say. But I mean, does that meet that head on?
I suppose.
Yeah. Commissioner Stebbins, any?
No, I like that suggestion. Maybe even get it notarized.
Yeah, I think that's an appropriate step as well. Do you want to talk a little bit about the entire
Sure.
project
No,
here?
this is anything that needs discussion will be discussed now.
Things that are important to me with this whole process is, A, that there is no evidence whatsoever that the applicant knew about what was happening behind the scenes with the land transaction. That to me is a very important piece of this. I actually want to commend law enforcement, our state police, IEB, excellent collaborative police work, and which I suspect may not be over. And we've turned it over to the appropriate law enforcement agencies here. You know, for a situation like this, is probably never a perfect solution. I think we have to look at the best interest of the citizens of Everett who voted overwhelmingly in support of this project. You know, I'm convinced that the applicant, the representatives took the matter seriously, understood the concerns of the IEB, and I'm convinced they worked to come to a resolution that we could find acceptable. I wasn't sure there could be, I'll be honest with you. But I am persuaded by, you know, this is not something the applicant wants to be involved with. They took it seriously when our IEB brought them the issues. And I, for one, could be persuaded to, you know, in the best interest of all parties, and I'm really talking about the people here, the citizens, more than anything else, that I could be persuaded to move with this resolution, and we're doing our best to keep it clean, to keep it safe, expanded gaming, and you know, the right law enforcement folks will be taking a look at this matter. So from a regulatory standpoint, I believe we've done a very good job here.
I would agree. I would echo the Commissioner Cameron's points about one, the work of the IEB. I think as we've gone down the road of doing these suitability investigations, I'm not sure we expected an investigatory wrinkle like this to pop up, but I appreciate how thoughtful and diligent our team was, and again, bringing the issue to our applicant and how they responded. Coming into this, I think some of my biggest questions were addressed by Mr. Laporte. You know, I think it helps to get an explanation of a piece of property bought for $8 million that's has some level of contamination, or obviously a nice piece of property like that would have moved hopefully a lot quicker. And it was helpful to have the explanation as to how the $8 million sale price got to a fair market value of $35 million. So I appreciated that input.
Well, it's technically 25, but it's good. It's good that you're saying 35, because there's a 10 million that goes into remediation. I'm similarly persuaded by all the comments as well. I was very focused on the notion of remediation, how it came about to value that piece, because that's liability that the applicant retains. But I'm persuaded that it's in the interest of the applicant, in order to develop what they plan to develop there, to dredge and you know, excavate a lot more than what would otherwise have to be done on a commercial use, which is a differential when it comes to whatever liability you acquired and $10 million. So I'm also very much echoing all the comments made here relative to your lack of knowledge of the situation that was uncovered by the IEB, but your swift steps to try to address those. So it's good to hear.
Well, I certainly echo what everybody's said thus far. The key ingredients for me are, first of all, the independence and professionalism of the IEB. Once again, the IEB pursued a narrow thread that appeared on the horizon and took it as far as it needed to go in order to uncover some, at the very least, some cover-ups and some lies, I think it's fair to say, that were made to investigators in a piece of a transaction, though not involving the applicant, that lay behind the applicant and that the applicant was unaware of. And it was the IEB and the diligence of the IEB that uncovered that, and that's not the first time that that's happened. So I think we can take great comfort in the fact that the IEB is staffed by and headed by a professional, diligent public servants who are doing a great service to this Commonwealth. So that's the first thing. We did this once again, and we uncovered it. The second thing is the applicant had no role or participation in it, and immediately upon being informed that it was there, took prompt and aggressive steps to come up with a remedy. The third is that the remedy included a thoughtful, careful, exhaustive appraisal of what a fair market value would be for a non-casino use, a use that anybody who was in possession of ownership of this property could get for a non-casino use, if the property were sold for a non-casino use. I've seen a lot of appraisals over the years. This is as thorough, comprehensive, and thoughtful an appraisal as I've seen, and so I have great confidence in the values that are stated there. This, of course, is all an art. You can find some appraiser who will be a little higher, a little lower, but this is a thoughtful, careful, well-done, thoroughly considered appraisal, and I have great confidence in it and great confidence in the explanation that we heard today. So I think I am prepared to rely on that as a value that could be obtained, a reasonable, fair value that could be obtained for a non-casino use. And therefore am therefore I'm prepared to approve this as a solution to this difficult problem. We'll call for a vote here in a second, but there are two pieces of this that I'm going to put in a motion, or I'd like to discuss before I make a motion. And the first is that the crux of this problem is that nobody has been candid with us. And so a simple signed document that nobody else is going to get any money out of this is not, quite frankly, good enough for me. I would like to have, in fact, I would like to discuss with you, my colleagues, the necessity for having everybody who's going to get something out of this sign that document saying that we are the people who are going to get it, and sign it under oath, so have it notarized, so that we finally can get to the bottom of where this money's going. Now, that wouldn't prevent somebody who invested some money from getting the investment back, but it certainly would mean that none of the appreciation of this property that came from the sale at this commercial price goes to somebody who's been dishonest or lack of candidness. And so I would like to see that included in the ultimate resolution. And the second thing is, I would like to include in our motion that we refer everything that we've got to the appropriate law enforcement authorities, the U.S. Attorney, the District Attorney, the Attorney General. This commission cannot succeed in doing its work if people are not going to be candid with us. It is intolerable to have people tell us things that aren't true. It's intolerable for people to hide things from us. It's intolerable for people to behave in a way that requires us to chase them around to get the answers to simple facts. And we've got to demonstrate that point early. We've got to demonstrate that point often. And so I think it's essentially important that we include that in our disposition. So those two are open to discussion. Welcome to hear before we make a vote or make a motion.
As usual, there's very little to add to your well-articulated remarks. I would totally agree with that. That's where I was trying to ask about when we were talking about this beneficial ownership, and I suspect that asking them to all the parties that would benefit from this to sign on their oath would go a long way. Especially given that this matter would be referred to the appropriate authorities. They would know better to sign on their oath.
I would agree with that. I think this matter also is maybe should invite us to, we obviously place a great deal of emphasis on applications, license applications, things coming down the road. We talked about it today in terms of accurate information that both vendors and potential employees of casinos submit to us in terms of their accuracy and their truthfulness. And I would think at some point we discuss maybe some level of penalties beyond just denying somebody a license. Making us chase around after inaccurate information or expend a lot of time with people who are being less than honest with us, as you pointed out. But I agree with the two provisions of your motion.
Sure.
I'm in total agreement with everyone's comments, and certainly the resolution as you've proposed is acceptable.
All right, so then I move that the commission accept the resolution proposed by Wynn MA to the issues that arose out of the land transaction about which we've heard today, with the essential ingredients that were outlined. That is that the sale price be no more than $35 million with the $10 million proviso for cleanup costs, net of the $10 million or whatever portion of that needs to be spent on cleanup costs. That, number one. Number two, that the three members of FBT LLC who are nominally going to receive the proceeds be required to sign a document saying that they are the exclusive recipients of the proceeds and that they do that on a notarized document under oath. And three, that the IEB be instructed to deliver its entire file in this matter and to deliver its entire file in this matter to the U.S. Attorney, the District Attorney for Suffolk County, and the Attorney General. for such action, if any, as one or more of those bodies chooses to take. Is there a second? to that?
Second.
All in favor?
Aye.
The ayes have it. Aye. The ayes have it unanimously.
Thank you very much.
All right.
Thank you.
That then concludes the business for this meeting. I'll entertain a motion to adjourn.
So moved.
Second.
All in favor?
Aye.
Thank you.